Okay, so let's start. Good afternoon and welcome everyone to this 12th International Workshop of the UNESCO Housing Chair, which is in this case entitled Homeownership and Possession from Expropriators to Expropriated. Today we will deal with the effects of communism regimes, squatting and possessors in the human rights of ownership and housing. All this contextualized with the COVID crisis. And for this purpose, we invited 3 experts on housing law. I would like to briefly introduce Dr. Matusik from the University of Silesia, Poland. He's Doctor of Law and a legal attorney and a recognized expert on Polish private law. The second speaker will be Professor Roark from the Southern University Law Center in the States. Professor Roark writes in the areas of homelessness, poverty, urban law, and affordable housing law. And the third one, the third speaker is Dr. Alessandro Dinisi from the University of Pisa in Italy. He's an expert on Italian property law, possession, and the right to housing. Welcome and thank you all for joining us today. Every speaker will have about 20 minutes to present his research. And during the presentation, please use the chat that you have, the button here to send your questions and comments. And at the end of the 3 presentations, I will read the questions and the speakers will have some time to answer them. So, if you're ready, let's start with the presentations. The first speaker is Dr. Matusik, who will explain the restitution and privatization of real estate in Poland and the legal position of the tenant in all this process. Thank you very much.
Thank you very much. Thank you for the opportunity to make a short presentation about Polish or even Eastern regulations, civil private law, and problems with nationalization. Maybe if we could show this presentation, it's not a big presentation, but a few information is, I suppose, important. And I want to present 3 aspects of the problem. So the first aspect, it will be the notion of nationalization, because the notion of nationalization, especially in countries of so-called Eastern Bloc, is combined and it's complicated. Because we have contemporary today aspect of nationalization and historical aspect. The second part, it will be a short presentation about types and methods of nationalization in Polish and even Eastern Bloc countries area. And the third part, it will be connected with position of tenants, possessors of premises, which are restituted. So when the former owner regained ownership and possession of the premises with this tenant, and what is the problem of what are the legal problems with this situation? What the nationalization is a legal event which results in the acquisition of ownership by the state treasury. State treasury, I suppose you have the same conceptions, the same regulation, but in Poland, the state treasury is a conception of state which acts as a partner in civil law. So the state treasury is has the same position as natural person or legal person. The state treasury is a legal person. The state, of course, could act as an imperium, as a power with non-equal position, but it's not as. In that situation, it's not a state treasury, but a state. So the nationalization is a legal event resulted in acquisition of ownership by the state treasury, especially immovables, but of course it is a problem also connected with movables, enterprises, but especially immovables. And this nationalizations goes by the virtue of a general and abstract act. So it's not directed to a specific addressee, it's not directed to a specific subject, and it could be used repeatable. And this is a legal notion of nationalization. Today we have two important standards of nationalization. So first, the nationalization could be only done for the public purposes, public aim of acquisition. And the second standard, the nationalization could be done only with just satisfaction, with damages paid to the former owner. Unfortunately, in most cases, historical cases of nationalization, these two standards weren't fulfilled. The damages, even if we had damages in our acts, historical acts, it was only a symbolic. So it wasn't a just satisfaction. What about types and methods? I have to point out four important legal acts connected with nationalization. The first is a decree of agrarian reform. Agrarian reform, it was, I could say, core business of a communist regime, of communist authorities, not only in Poland, but in every country of Eastern Bloc. The agrarian reform was connected with, we could say, problem with ancien regime, with capitalism, which communist authorities wants to destroy. So the decree of agrarian reform from 1944. This legal act, I must say, is still in force. It was an episodic regulation because after the 1944, everything which, every immovable which was nationalized, it was consumed by this act, but formal, it is still in force. The second act, it was a decree on ownership and use of land in the Warsaw area. It was a very specific act, only connected with Warsaw, so the capital city, of course, of Poland. It is called Warsaw Decree in a shortage. The third act, of course, the Warsaw Decree is also in force, I must say. It's still in force. The third act, it was the act of taking over the state's essential branches of the national economy. It was from 1946, a legal act. And the subject of the seizure was the immovables, also with apartments. And the fourth act, it was a decree on the acquisition of some of the forests. Also the big problem, because the area of the forest in Poland is something like 40–50%. It was. Now it's, of course, another situation, but in those years it was something about 40–50% of the area of Poland. And what about the mechanism and methods of nationalization? We had four, but three is more important methods of nationalization. The first, it was a nationalization by the power of law, without, of course, without any compensation and without any remuneration, but by the power of law, without necessity of enacting any other legal act, decision, or something like that. So it was doing only by the virtue of law, of the bill, of a decree. In some cases, it was only necessary to enact a certificate of nationalization, but this certification was enacted by the state treasury offices, the same, of course, offices which was the beneficiaries of the nationalization. The certificate was important only to make an entry to the land register. So it was the first type, first method. The second method, it was nationalization by the power of law, but with the necessity of fulfilling the administrative proceedings. And these proceedings ended with issuing an administrative decision. Of course, we have different types of these decisions: declarative decisions, constitutive decisions, but it's important only to say that the administrative proceedings should be fulfilled. This mode was used to the acquisition of real estates, especially in agrarian reform, and contemporary have problems with this method. At first glance, the first method and the second method is similar, or even the same. But in the first situation, today, I mean contemporary, it is possible to initiate the judicial proceedings in which the court may decide whether the property fell under the decree, regulation, another act, regulation. So because we haven't got any legal decision from the history, so today, without any time limitation, without any prescription, the court in judicial proceedings could examine a problem from 60, 70 years ago, if immovable was fit with the decree. In the second mode, in the second method, also today it's possible to annul the decision and the supervisory proceedings in the Polish Code of Administrative Proceedings. We have the special supervisory proceedings, especially resumption proceedings. And in most cases connected with nationalization, there is no time limitation, no prescription, no administrative limits connected with time to start the supervisory proceedings. So the decisions from 40s, 50s, 60s of 20th century could be annulled, could be thrown to the dustbin, we could say. And of course, because of this proceedings, judicial proceedings or administrative proceedings, today we have problems with restitution of immovables, because state treasury could be erased from the land register, and the former owner or heirs of the former owner could be entered in the land register. And the third mode, the third method of nationalization, very interesting and complicated, unfortunately, which was referring to the area of pre-war, pre-Second World War, Warsaw. It was based on...
אתם יכולים לתפוס אותי בימים הקרובים, יום ולילה.
Excuse me, I don't understand. May I continue, or I should stop?
Yes, please continue.
Okay. This third method was based on a seizure of ownership of the land, but only of the land. So the land of the Warsaw area was seized by the state treasury without, of course, any compensation. So all plots of land was seized by state. Ownership of the buildings in the Warsaw area located on these lands remained with the former owners of the land. So as you can see, it results in different status of the land and different status of the buildings. Former owners of the land, we called them decree owners. Decree owners were empowered to submit applications for granting perpetual usufruct, a specific real right to the land, not ownership, but something like that. So the decree owners were empowered to submit applications for granting perpetual usufruct for the land on which their buildings were located. And if the application was dismissed, the ownership of the building went to the state treasury. If this application of decree owner resulted in granting the perpetual usufruct, so it was a positive decision, the ownership of building remained with the decree owner. Very complicated composition of rights, as you see. And of course, most of the applications were declined, were rejected, but without justified reason. The Warsaw Decree gives a prerequisites to reject the application, and the authorities declined the real right to the land without legal reason. So as you can see today, these decisions could be annulled with supervisory proceedings, and of course it happens. So in summary, I can say many errors, many negligence during seizure and application of these decrees we could find in these proceedings, and today it could be repaired, and the decision could be removed from the legal order, and it happens. And what about situation of a tenant or another possessor of a premises? After regaining the ownership of land, of course, now it could be built up with the multi-apartment building or with something else, because we have superficies solo cedit rule. So after regaining the land, of course, everything which is on the land is also regained by the former owner of the land. So after regaining the ownership, after entry to the land register as an owner, of course, with a retroactive effect, I must say. So with extung effect, this former owner becomes an owner not from the, for example, 14th January of 2020, but from the 1944. Former owner or heir of this owner. And what about the tenants which are in the premises, in the buildings, in these apartments? Of course, the tenant's right to the residence and premises is based on a tenancy contract, tenancy agreement, or tenancy decision. The tenancy administrative decision, because in Poland we have housing administrative regulation till the 1994, so 30 years ago. But these decisions are of course, still in force. So the tenant's right to residence in the premises is based on a tenancy contract or a tenancy decision, and the legal relation links only the tenant with a former landlord. So state treasury, for example, municipality or entity which was granted by the state treasury or municipality with the right to tenancy. So the legal relation is only with the former landlord and a tenant. There is no legal relation, I mean contract or tenancy connection between actual owner and the tenant and the possessor of the premises. And in courts we have three major cases connected with these legal circumstances. Of course, there are many different problems, but the three major problems I want to present you. So the first one is, of course, eviction proceedings. Eviction proceedings with many, we could say, misuses of rights to eviction. The tenants have a narrow range of legal arguments to defend their position. The last castle, we could say, the last castle is an allegation of misuse, abuse of ownership right. Misuse, so that use of the ownership is incompatible with good faith. But as you can see, it's very it's very hard to. It depends. It's the effect of this argument, the effect of this allegation. It depends on the decision of court. The second cases are the cases connected with where the tenant is treated as a possessor of premises with bad faith. It results in an obligation to pay the remuneration for non-contractual use of the part of the movable of the premises. Bad faith of this tenant, of this possessor, may be recognized if a tenant had an opportunity to check the situation of the building, the situation of the land, of the immovable. So to examine the documents in the municipality land register. In Warsaw, for example, because of common knowledge, everyone knows about so-called wild reprivatization and swindles with reprivatizations. Everyone knows. So in Warsaw, because of common knowledge about it, about the problems with reprivatization, it is possible to accept the possessor bad faith from the moment of initiating the remuneration proceedings or annulment proceedings, annulment of the decree decision. As you can remember, I said that former owner was empowered to submit application for granting perpetual usufruct. And when, for example, 5-10 years ago, this former owner started the annulment proceedings of this decisions from 60s, 70s of 20th century, when he started these proceedings, the bad faith of possessor, the bad faith of the tenant could be recognized. And we have in courts problem with that. So a tenant is paying a rent for a state treasury, and now, after losing the legal proceedings with former owner, he has to pay a rent or non-contractual remuneration to the former owner. And the third problem, the third aspect, very often the tenant is strictly a subtenant of the premises. Not a tenant, but subtenant of the premises. The administrator of the building, of course, on a different legal basis, is an enterprise. It could be even a public entity, public enterprise, owned by the municipality or the state treasury. And this administrator, this public entity, is treated as an independent possessor as an owner. After regaining ownership, formal regaining of ownership by the former owner or its heirs, the public entity becomes a bad faith possessor, the bad faith possessor. But this administrator, this entity, collects rent and fees from subtenants. And as our Supreme Court ruled a few years ago, this public entity, this bad faith possessor, is obliged to pay as a non-contractual remuneration to the former owner only what this entity collected as a rent from tenants. So this entity gives a former owner only what was collected as a rent. And there is a large gap in such a system because public entities applied non-market amounts of rent and fees to the tenants. Because of it, it is a way to sue a subtenant, the former owner, which regains the ownership, has a way to sue a subtenant to pay the amount of rent which was his benefit. Yes, because when we compare a rental amount level of rent and the level which was collected by public entity, this amount which is the effect of this comparison could be the subject of the judicial proceedings. I suppose the courts will find a way to fulfill the both sides' interests, but now we have legal problems, and these problems becomes a social problems. So evictions, non-contractual remunerations, and the problems with comparison of rental and not rental level of rents. And I suppose it will be enough for me, and it's of course only a general view of this complicated problem. So thank you for now.
Many thanks, Dr. Matusik, for this overview on the nationalization process in Poland and its problems regarding all the restitutions and how is the situations with tenants. I would like to remind that you may ask questions or make comments using the online chat, and at the end of the three presentations, I will read them and the speakers will be able to answer them. Okay, the second speaker is Professor Roark, who will explain another perspective, in particular the effects of COVID to squatting and squatters, and how the states responded.
Okay,
yes.
Can you hear me now?
Now, yes.
Okay,
Fine.
Great. Okay, and can you see the slideshow okay?
Fine, perfect.
Okay, good. All right, thanks again for having me here. I'm going to be presenting on squatters and COVID. This has actually become the final chapter of a book that Lorna Fox O'Mahony and I have been writing titled Squatters in the State, looking at how states respond to squatters and what that tells us about the property system, and what that tells us about how the state relies on the property system to shore up its own resilience. And so one of the things that we start from is we start from this perspective that squatting is a problem that's regularly framed as one particular type of problem, but it oftentimes presents several different types of problems. So we call it a wicked problem, in that homeless squatting on empty land is a large-scale social challenge caught in causal webs of interlinking variables that span national boundaries. The causes of homeless squatting are complex, and they're contested through various narratives or norms that we apply, including legal norms that shape the way we think how parties should respond. And so depending upon the frame, we might perceive squatting as a housing and homelessness problem, or a social exclusion problem, or a property rights problem. We might perceive it as a neighborhood problem, a problem that neighbors have to deal with amongst other persons on property. Given the last few years, we've certainly talked about it as an immigration or a securitization problem. And even in the last year, we could even add to this list a public health problem. That sometimes we think about squatting in the challenges it presents through these lens, or sometimes the way we frame the problem within how we shape policy with the state, that maybe it's just not a problem at all. Maybe it's just a reality of modern life that we have to sort through. So our starting point for this book and our method of unpacking this problem is to consider this through the lens of multiple different actors, including the state. So one of the problems with framing something like squatting as one of these types of problems is that we tend to only look at it through one perspective, the owner's perspective, or the squatter's perspective, or a social perspective, or the state perspective. And what we're really trying to do is we're trying to map the entire problem space of squatting, to look at how does squatting how does the state interact with squatting from multiple different levels? And we start with the perspective of building off of vulnerability theory, Martha Feynman's work, that unveils that all humans and human institutions experience vulnerability with different levels of resilience. We have added on to, or our insight into vulnerability theory is that the state itself as a human institution is also inherently vulnerable, that it experiences vulnerability that it seeks to shore up its vulnerabilities through various acts of resilience, and that private property becomes an important asset of that resilience making that the state relies on to shore up not only individual resilience, but also to shore up its own resilience. Now, within that, the state tries to maintain a space of equilibrium where it maintains a stasis of its legitimacy across the entire sector. But then things happen, crises happen that throw the state's ability to maintain that equilibrium into flux. And so this creates what I call the crisis cycle, where the state identifies a particular crisis, it then responds. That response can create a different vulnerability that wasn't revealed, that the state wasn't focused on when it first identified its crisis. And then that new vulnerability creates a new crisis that the state has to respond to. When we think about this and we think about how the state is pursuing equilibrium, we know that the state can do a variety of things in order to shore up its own legitimacy in that context. And so since the goal of the state is towards resilience in the face of ever-changing circumstances, what we are asking is we ask, well, how do state responses to squatters impact that ability to be resilient? And in our work, in our book, what we're looking at 5 jurisdictions in the main portion of the book, chapters 1 through 9. And then in chapter 10, we turn to South America, to Argentina and Brazil, to focus on those jurisdictions more acutely. But we look at England and Wales, Ireland, Spain, South Africa, and the United States to compare and contrast how these different systems deploy property or rely on their property norms in order to maintain that resilience. And then how does that affect their ability to preserve equilibrium? How does that preserve their ability to remain resilient in the face of broad-scale challenges? And we think that squatting reveals that. And so I'm going to kind of unpack that a little bit. When we talk about resilient systems, they're typically identified four markers for what makes a state resilient. One is the flexibility to absorb stress or pressure. So the state's ability to change or to navigate that crisis space. A second characteristic is that it can recover from challenges or crises. That not only does it have the flexibility to adapt, but it has the ability to recover and to maintain its original posture, its original equilibrium. A third characteristic is that states that are able to be resilient are adaptable. So they're able to change in response to a stress on the system. And this is different from being flexible, right? So in a flexible state, the state generally remains consistent or the same, but it's able to flex its own institutions in order to address a particular challenge. Adaptability means that the state is able to functionally change itself. It's able to change some of the basic ways that it relies on its institutions in order to adapt. And law is a primary way that the state is able to adapt or to flex in these scenarios. And then fourth, states that are resilient tend to be innovative. They tend to be able to change more efficiently or effectively to address the challenge or the crisis. And so if we were to overlay these steps against the crisis cycle that we've called, we might see the different points in time where these characteristics occur. That the flexibility of response often is pushed inward against the state crisis, so that the state is able to respond, is able to flex before its response creates a different mechanism. It is a part of that responsive mechanism. That when the state is able to recover from crisis, it's often because, and this is number two, it's often because the state has built-in mechanisms that enable the state to recover from crisis, that the state has these built-in institutions that is able to be responsive. That the state responds by adapting means that the state is pushing out into a different cycle, or it's pushing out into a different version of itself, or something that looks a little bit different from the state. And then the state's ability to be innovative or responsive tends to address its ability to be efficient. So now, as we think about squatters and how squatters interact with this cycle, they interact with the cycle because squatters are oftentimes presented as threats. Their presence through possession of property presents a threat to the traditional allocation of rights and property, or at least some versions of that traditional allocation of rights and property. And if we think about it, if we kind of pull back the lens of what exactly squatters are a threat to, we can name various examples. So for example, they may be threats to social identity. We see this emerge in the way that travelers are particularly vulnerable to state intervention relating to squatter occupations on empty land. It may be that squatters present threats to economic interests. So, for example, in England, with the passing of the Land Recordation Act and then Las POA, in the 2000s, these were really drawn on threats to the economic stability that England was perceiving that the mortgage foreclosure crisis had presented to the state. These two acts together, though at different times, had kind of combined to really be this way, this way of encapsulating the threats to those economic interests. And the same thing in the U.S. So we see in the U.S. a shift towards criminalizing squatting in certain states that were particularly hard hit by the mortgage foreclosure crisis. We could see squatters as threats to political stability. So, for example, in Spain, the passing of Article 245 has often been attributed to the rise in the autonomous squatters movement through the 1980s, and in particular in the early 90s, as Spain was gaining greater national or greater global traction through these large-scale events, and that squatting centers had become a site of social organization. And then we could also see these as threats. Sometimes they can be perceived as threats to state interests. So, for example, since April, since COVID has really started in South Africa, there have been more than 30 new squatter informal settlements that have popped up around Cape Town, South Africa. And those squatter settlements typically have been on public land. And so a public official recently talking about these settlements talked about the impact and inability of the city to take on new public projects like hospitals or community centers or other potential uses for that land. So when we look at this in kind of a global context, and that's one of the things we try to do is that what moved us towards thinking about this project was thinking about how in recent years we have seen this growing tendency to shift state responses away from private remedies, which was the traditional mechanism for dealing with squatters. If you had a squatter on property, that the law typically empowered landlords or empowered owners with all of the remedies necessary to go to court to get an order to evict the squatter from the property and to reclaim their interest. And if they didn't do so over a particular time or a long enough period of time, then they face the possibility of losing that property through adverse possession because someone may be utilizing it in a more useful way. And this has traditionally been the way that we have framed and talked about squatters over time. We spend a good amount of time talking in the book about the U.S. and how in the U.S. the adverse possession and these remedies of trespass really became a way of settling the western frontier and dispersing of land in a way that was useful for the growing country. But in recent years, we have seen, starting with Spain in 1995, but then moving into England and Wales in the 2000s, and in the U.S. in the late 2000s, this shift away from private remedies, either making the exercise of those private remedies more difficult, such as through the Land Registry Act in England, or even by overtly criminalizing the action of squatters that possess land or that possess property without having a legal interest. One of the things that we talk about in this work is the tendency of framing those problems tends to jump scales of rhetoric in the way that we socially perceive problems. So we perceive the squatters problem very differently when we start talking about it as a criminal action versus as a housing action. All of a sudden, we have put this moral imperative on the act rather than dealing with the problems that may underlie the squatting in the first place, such as the increased cost of housing in communities or the reduction of affordable housing in communities. That by labeling the acts as criminal, what we have done, what the state has done is it has essentially created the moral rhetoric through law that justifies or validates its action or legitimates its action to the public. And so if we were to think about squatters across the crisis cycle that we presented earlier, we might think about it as any one of these number of threats, either a social threat or a political threat, an ideological threat, or an economic threat, which prompts certain legal responses, criminalization or the reduction of private law remedies, which then may create, if that response isn't sufficient to restore the state back into its place of equilibrium, or if it leaves open the potential for other action, what it may do, and what oftentimes it does, as we've seen across the squatting threshold, is it creates this new emerging threat, that there's a new type of threat that may be different relating to that squatting. That squatting may have started as a housing problem or a political problem, but now the state's response to it has, because it addressed only that part that was threatening its legitimacy, it has now opened up this new problem space because the problem that drove it in the first place was never addressed. And so now it's a housing threat, or now it's some other type of threat, which could lead to social mobilization and reduce state legitimacy, which then creates a new crisis. And the crisis kind of continues on and on and on. And we wouldn't just stop at squatters because, as I said, what we are doing in the last chapter, chapter 10 of the book, is we are overlaying the current COVID problem. One of the benefits of writing a book in the middle of a global pandemic, it's not all bad, I guess, is that you now have a new framework or a new problem space to talk about the problem that you're working through. And that's exactly what we are trying to do. And in fact, if we look at COVID and the way that the state responds to COVID, we can see a similar crisis space that has opened up. So for example, as the state faces the spread of COVID-19, it responds by implementing community lockdowns. Those community lockdowns could have the effect of economic reduction, so layoffs or reduced economic activity that threaten individuals' housing stability, so an increase in housing precarity arises. And as that housing precarity arises, we see a growth in squatter settlements, which then creates an increase in COVID spread. More COVID spread, more threat that emerges. And we could even lay these cycles right next to each other, because the one thing that we know is that states are not binary. They're not always dealing with one problem or the other problem. They're always dealing with common problems, and those common problems overlap. And so our tendency to think about this challenge through only one lens means that we may be contributing to the other lens. That the squatting response cycle can absolutely affect the COVID response cycle, and vice versa. So let me give you some tangible examples. I've talked a lot at the high level, so everybody likes the examples and they like the pictures. So let's do some examples and pictures. One way that states have responded to COVID is through moratoriums on evictions or other legal proceedings in conjunction with state lockdowns. So the ability of the state to eliminate or to reduce the amount of housing precarity that individuals face as a result of the reduction of economic opportunities. And this generally comes and has been validated by the state in two ways. One is the need to maintain a lockdown or to maintain close no contact orders, and at the same time recognizing that some people are going to lack economic means of maintaining their housing, their current housing stability. So, for example, England, in its coronavirus protections, extended notice periods to 3 months initially in March, and then again in August to extend those periods through December, and then has recently done so again to extend these notice periods to February, basically spreading out the time that an eviction may take during this time. It also limited local bailiffs' legal right to carry out an eviction where lockdowns were necessary to maintain social distancing. You see in some places extended housing benefits that were intended to shore up landlord and tenant housing security. So if landlords had mortgages on property, then you saw some states stepping in or providing resources that may enable access to either legal remedies to delay payments, or even in the case of tenants, access to resources that they could pay landlords through in order to maintain their housing status. But one of the things that also happened in this time was that even though we had moratoriums on evictions and moratoriums and other legal proceedings, one of the downfalls, or one of the backdrops of that, was that the courts were not necessarily available to stop other types of actions that might have threatened persons that sat outside of the scale. So, for example, in June 13th, 2020, there was an attempt by a local privatized security company known as the Glenfrome Road Council to evict travelers from an empty parcel of land in Bristol, England. And that's the picture that you see on the screen. The local security company caused havoc. When local authorities showed up, the local security company presented papers to the police officers. The police officers' response was that this does not look entirely legitimate, and they refused to enforce that the security company's action in evicting these squatters. But the point is that there was an inherent vulnerability in this moment where a local security company was able to step into the breach of not having sufficient legal remedies to protect other persons, when arguably the law would have protected them. And one of the things I would say about that is I'd say that oftentimes when we see squatter camps, particularly in formal settlements, or we see squatting centers, Oftentimes, these are seen outside of the traditional property paradigm. We don't really know what bucket to put them in. Are they tenants that have rights like tenants against landlords? So landlords have to respond in that phase. Are they trespassers that parties can seek remedies against? We've also seen this in England in relationship to businesses that have been able to skirt past these anti-trespass rules. Just a couple more screens and I'm done. I'm going to skip over this. This is the U.S. approach to moratoriums. We can talk about this in detail, but the U.S., in as much as it had 50 states, had 50 different responses to how to think about a moratorium. 54 if you want to talk about territories and the federal government, because they decided to get in the game as well. And so one of the main takeaway I would point to here, though, is that there was a tendency to not actually alleviate obligations to pay rent. Those obligations remained in place, even though the legal remedies, the courts were not open necessarily to hear them. The second approach is a continued forceful removal of squatters. So we have continued to see, even though we have moratoriums in place, we continue to see forceful evictions and removal of squatters. Two of the more prominent ones happened in both Cape Town and in Argentina. So in the Guernica, Argentina, the police entered and demolished homes that were made of cardboard, metal, and sheet metal and wood. The owner of the parcel had planned to develop a country club style resort when squatters occupied the land. And then the squatters had moved in as a result of loss of income. So they had lost income, moved out of the city. Many squatters settled into this space, established precarious housing structures, but not very precarious. And the landlord on October 29th moved in with the assistance of the state to have these squatters removed. And this is an example of the state continuing to promote the resilience of the owner interest over other interests, or to take into account and not being able to see other interests that may emerge. Saw a similar action in Cape Town. Cape Town has had a number of squatter or informal settlements that have emerged around the community, and mostly this has been a function of not deploying resources to address losses of income related to COVID, but also not addressing the potential for landlords to create or to evict tenants. The third response has been to provide temporary spaces for rough sleepers. So this is a picture from Las Vegas, a parking lot in one of the many hotel casinos of Las Vegas. You can see they placed taped lines down to designate spots for homeless sleepers to occupy. These spots were designed to create social distancing. Other communities in the U.S., England, Spain, and elsewhere have provided hostels, and temporary homeless camps have been created in order to reduce the potential for spread. And these solutions have been built on addressing the potential problems for social distancing as distinct from housing problems. So this is an example of the state looking at the crisis and saying the only crisis that they are addressing is the COVID crisis, not actually seeing the housing problem as being as being related to it. And so one of the things that we point out is that there is a fourth potential for reducing the vulnerability of squatter settlements. That one of the things the COVID crisis has revealed is that addressing large-scale challenges often requires dealing with housing problems, that housing problems are intersect with very many of our larger scale problems. Public health emergencies implicate sanitation, access to information, and reasonable accommodation. And these issues are more precarious as in informal settlements and in spaces where utilities are used to discourage occupants. The vulnerabilities in housing delivery by the state may reduce the state's store of legitimacy when it needs to communicate health policy concerns and notices or vaccine distributions. And that the scaling up of rhetoric by framing conflicts as one thing or another will reduce the state's ability to be adaptive or resilient and thereby challenges its own legitimacy, potentially leading to tipping points of its own equilibrium. And with that, I'll stop and love to hear your questions and comments at the end, and looking forward to the next presentation.
Many thanks, Professor Roark, for your interesting presentation, and congratulations for the book. I found very interesting the perception of the squatters as a threat, and even for the political stability. Okay, and at least finally we have our third speaker, which is Dr. Dinisi. He will cover the protection of the facto possessors in Italy during precisely the COVID crisis too.
Thank you, Rosa Maria. I'll just try to share my slides. Okay, you can see?
Yes, fine.
Okay, perfect. Thank you so much. I'm really glad to be here once again in Tarragona at the UNESCO Housing Chair that I've spent several months to study my PhD research that I want to present with this brief presentation that in which I would like to, as I said, introduce a part of my research that is about protecting housing possession according to the multi-level legal sources that in Europe that protects the right of housing. After that, after a brief explanation of the theoretical context that justified my research, I'll try to focus on the subject of security against eviction that I think it's more linked with the topic of this webinar. And then I'll try in the last conclusions to point out some aspect of legal measure in COVID emergency taken by Italy, of course. My research aimed at investigating how the protection of housing may influence the law of possession, looking at the multi-level legal framework, as I said, and namely some national provisions, constitutional provisions, such as Article 2 of our Constitution that protect, in general, is the general clause which protects unviable right, and after 1988 recognize the right of housing as included in the catalogue of unviable right, and also looking at the European legal framework, and namely looking at Article 8 of the European Convention of Human Rights and the twin provision of the Charter of Fundamental Rights, the Article 7, which protect the right to respect for the home. By the analysis of these provisions, I've understood what is known that the housing right notion is a complex notion that includes different interests and different claims. First of all, we have the social right, the right to housing, the right to of access to housing that involved primarily the state to provide housing solution for the weakest part of the society in case they cannot succeed to get access to house. And this claim has the typical structure of a pretension, a social right addressed mainly, as I said, toward the state. On the other hand, especially from the notion of right to housing deriving from the European provisions, we may say that there is other claims, such as we may define the right of housing, that is a right that recognize a conservative interest for who already enjoys of a home and want to maintain this enjoyment against different conducts that may be unlawful or sometimes also based on property interest, a concurring property interest. And then in another kind of claims that we have, we may recognize looking at especially Article 8 of the European Convention of Human Rights is the dimension of housing adequacy. That is not a protection, that not attribute a protection for from losing the home, but just about the quality of housing. And in this regard, disputes concerning emissions or nuisance are involved in the protection of housing adequacy. Especially the last two interests that I've mentioned involves and raise question about the against which who this claim may be claimed for, against the state, of course, but in some cases and in certain limits also toward private individuals. And this different provision has, according to this different provision, we have different extents of these horizontal effects of the housing interest. As I said, my research deals with possession. And I would like to mention in brief why I've decided to focus on law of possession. In my view, according to the legal notion of housing rights, we can find some features that are shared with the civil law institution of possession, since housing right is gives to the individuals a protection of the actual control over the dwelling, and this sometimes despite the absence of a property right over it. And this is another important aspect, especially for the protection of security of tenure, only within the limit of this actual control. And it means that housing right aim at protecting only the good use value and not provides profits from the commercial value of the good. This link between possession and housing, in my view, is strongly confirmed by the European Court of Human Rights case law. And when the Court of Strasbourg defined the scope of the protection of Article 8 and define the notion of home, which attract this protection. And the Strasbourg Court says that if we have a home depends not on the property rights over the dwelling, but on factual circumstances, and namely on the existence of a sufficient and continuous link with a specific place. This means, in my view, these sufficient and continuous links, if we try to translate in a civil law terminology this link, of course we look at the institution of possession for the reason that I've mentioned before. So now I'll try to stay on the subject on the topic of security against eviction, and I'll focus on Article 8 of the European Convention of Human Rights. The Court of Strasbourg define the loss of homes as one of the most extreme form of interference with Article 8 and with the right to respect for the home. And starting from this principle, the Court of Strasbourg started to develop a complex system of guarantees, both procedural and substantial, in case there is a severe risk of housing exclusion. But in this field, as is well known, when we deal with the European Convention and especially in the field of Article 8, we have to take in account that eviction must be distinguished between private and public interests involved. And in particular, we have to see if the eviction regards a public dwelling and is enforced by public authority pursuing a legitimate public interest. In such case, the home, if Strasbourg find a home for the individual that is involved in the eviction procedure, according to the notion of sufficient and continuous link that I've mentioned, the condition to check the compatibility of this eviction with the Article 8 applies, and in particular the lawfulness of the measure, the legitimate aim of the measure, and this means what the state aim at pursuing with this measure. And finally, the proportionality test that is introduced by the requirement of necessity in a democratic society of this measure and of the legitimate aim. The necessity is, as I said, the proportionality test. This means that the court balance the competing interest. On the one hand, the legitimate aim, and on the other, the housing interest on stability. And according to the measure concerning evictions, the Strasbourg case law has further elaborated the criteria for apply the proportionality test, distinguishing two different kind of guarantee that the state have to fulfill. On the one hand, there is the procedural safeguards. That is, in particular, the state has to motivate the measure according in the light of Article 8. And on the other hand, this motivation allows the individual to be aware about the reasons of the measure, and thus applying, and this is the second requirement, the second procedural requirement, to apply before an independent tribunal who judge of the necessity of the proportionality. Thus, this tribunal has to apply a lot of substantial criteria defined by the court, listed by the court in the case law that I've mentioned. First of all, we have to check if there were alternative possible measures to pursue the same legitimate aim. If not, in any case, the judge have to ascertain if there is a severe risk of homelessness, a severe risk of housing exclusion for who suffer the measure. And then, if so, the state is in charge of find alternative housing solution. Not in all cases, of course, but only in case in which the risk is strong, and for example are minors involved or minority groups who live in a specific place. After having defined how the control of Article 8 on evictions works, it's important to ask to see if this test may apply also in private dwellings, where there is a concurrent private interest of private owners to recover a good. In such cases, the Strasbourg case law does not apply Article 8 because they think that no proportionality test may apply in case in which a competing private interest is involved, because of the necessity is presumed. There is the necessity of the measure is always presumed. So no independent court may verify, according to this case law, the risk of housing exclusion, and then no responsibility for the state for the rehousing of occupiers. Having said that, one effort that I tried to fulfill was to find if the housing interests are maybe found in the whole convention, considered as a whole, and in particular looking at Article 1, Protocol 1, European Court of Human Rights case law. Because maybe looking at this article, which protects private property rights, we may find an influence of housing right in the fair balance of statutory legislation, a national legislation who try to limit the property rights in order to pursue housing aims and housing stability protection. And this is the case of the statutory suspension or staggering of evictions procedure that Italy tried to carry on in 1990. And in such cases, even if the Court of Strasbourg condemned Italy, they does not state that in theory and in general this kind of legislation are always in contrast with Article 1, and they listed the fair balance criteria to be in compliance with Article 1 despite the limitation of property rights. And one of these criteria is, of course, the duration and foreseeability of the suspension of enforcement evictions procedure. And on the other hand, another important aspect is evaluating if other concurring landlords' interests are involved, and if landlords and owners has urgent need, for example, for their own housing needs of the dwelling they want to recover. And finally, an evaluation of the authority behavior, and if the authority, the public authority, is inactive in trying to counteract the housing shortages with other measures. Thus, now we may, after having defined more or less how property interest and housing interest are balanced by the convention, we can try to see how this system works in the Italian legal framework. About eviction of public dwelling, we have to say that in Italy, according to the civil code, public authorities have a power of self-help. This means that the eviction of squatters, for example, may pursued by means of an administrative eviction, so without any applying before a court. This is not in theory in contrast with Article 8, but raised the question about if the individual, the occupier, may apply before an independent tribunal as required by the Article 8. No legislation expressly mentioned this power, but recent case law of the Court of Cassation, namely the Criminal Division, start to directly apply Article 8 and the proportionality test, especially in case of demolition orders as an accessory penalties. On the other hand, for eviction of private dwellings, we have to check if there is a legislation who go in the direction of protecting housing stability, and this legislation started in 2017 with a decree law who has the primary aim to go toward the owner's interest and recognizing a compensation for landlords in case of undue delay in enforcement eviction. But this provision under Article 11 of this decree law also mentioned the possibility in cases of special vulnerability for occupiers and the possibility and the power of local security authority to appoint a committee who is in charge of rehousing. This legislation is, of course, a first step toward involving state with positive obligation of rehousing, but there is some critical issues that we can point out according to Article 8. The first one is, of course, the exclusion of a control by the judicial authority, because it's the local administrative security authority that has the competence to ascertain the special vulnerability, and this is not in compliance with the procedural safeguards of an independent tribunals. On the other hand, there is no a clear definition of vulnerability and of which kind of rehousing measures are involved, and if especially this power of the local authority, of security authority, is a duty or just a free choice. After that, and really in brief, to finish this presentation, I would like to mention some measures of provided for the after the emergency of COVID-19, and in particular the measures of suspension of enforcement procedures provided by this decree law of March 2020. And we have two different suspensions. The first one regards real estate foreclosures, and only concerns the debtor's main residence. The second one regards is more general and regards all repossession judicial orders, including orders that not concern a tenure for housing purpose, but also for commercial or touristic purposes. This provision has been prorogated many times, and with the last prorogation in December 2020 and until the 30 June of 2021, the suspension was limited only to eviction for failures to pay a rent. This is a first problem that I would like to just point out, and it's the end. Is the third one that I mentioned in this slide. The problem of that the suspension now exclude the other kind of repossession orders from the suspension. That for example, the eviction due to the end of lease or squatting or due to squatting, and this may create some problem and with for the compliance with Article 8, especially in conjunction with Article 14 of the Convention, which require that there is an equal treatment in protecting people who are in the same situation and require and needs the same housing stability. On the other hand, other problem regards for example, the extension of this suspension that concern both tenure for housing purpose and for other purpose. And this may be in contrast with Article 1, Protocol 1, as I said, because it's not justified by the legitimate aim of protecting housing stability. This is the end. Thank you for your attention.
Many thanks, Dr. Dinisi, for your presentation and this complete analysis of the international mechanism. I think that someone, no, okay, now I can hear it properly. So I was saying that thank you for this complete analysis, and we saw all the international mechanism to protect housing and how it is applied. Okay, now we have time for discussion. We had quite interesting questions in the online chat. In fact, if you follow the chat, you can see that some questions were already addressed by the speakers. So I will read only the ones that are not responded. I also received some private questions, so I will start with a question to Gregor, okay, to Dr. Matusik. The participant asked, given the experience of forced expropriation of homes in your country and in many Central and East European countries under communist regime, what do you think about recent policies in Spain allowing the expropriation of properties if they are kept empty for 2 years in Spain? Do you think it is a legitimate action, or should the owner be free to keep them as such?
Okay, so I have to answer now, yes, online. So this construction in Spain, could you repeat what is the mechanism of the expropriation? Because I don't understand exactly.
Yeah, the participant says that the government, the regional government, can expropriate a home if it's empty for a certain period of years, in 2 years. Okay. So what do you think about it under the experience of your country?
Yes, we have a very good question, and I enjoy about this question because we have a long history about the abandoned property in Poland. After Second World War, the problem of abandoned property, immovables, buildings was enormous. And in Poland, we had a decree of abandoned properties. Of course, the reason of abandoning property, it was not important. It was only important that for 10 years, we have a period of 10 years of the end of the 1945, the period of time when the owner was absent. And after this period of time, from the kind of prescription, because when we are looking for legal institutions, it was a kind of prescription. After this 10 years, the ownership of the immovable goes to the state treasury. And it was acquisition by silence, we could say in English. Acquisition by silence. It wasn't acquisitive prescription because we don't have the state treasury. It wasn't necessary that state treasury should be a possessor of this abandoned property. It was only important that the property was abandoned. And contemporarily we have judicial proceedings because, for example, heirs of the former owners starts the revocation proceedings because the acquisition by silence after this 10 years was proceeded by the court. And of course, we have a large gap in these proceedings because the proceedings should have sides, parts, and the part of the procedure should be the former owner or the heir. And of course, the communist authorities didn't fulfill this requirement. So today, this finished proceedings could be started again. So what can I say? The conception of abandoned property is also deliberated in Poland today, and in many attempts about reprivatization act, reprivatization bill from even 3-4 years ago. We have the last attempt, the last real attempt about it. It was an idea to enact rules about acquisition by silence by the state treasury for abandoned property, but only to regulate the situation of the empty buildings. I don't know exactly, is it a good idea to do it by the acquisition by silence? I suppose the better idea is to use the rules which all private systems of Europe has in its codes. I mean acquisitive prescription. It isn't necessary to put a new institution, abandoned of property, acquisition by silence. The best idea is to use the acquisitive, and the most important prerequisite to acquisitive prescription is possession and period of time, and it's enough to fulfill these problems, I think, to solve these problems.
Okay, thank you very much for the answer. I have another private question in this case for Professor Roark. He asked, do you think that there should be a different legal treatment to different types of squatters, depending, for example, on their reasons, their economic background or behavior? Wouldn't this be a call for squatting?
Sorry, I had to unmute. Okay. So I think the question unveils a really important point that we are trying to elicit, which is that I think there's a tendency to try to treat all actors exactly the same, everyone the same, and assume that legal approaches have a one-size-fits-all category. And that may feel right from an efficiency perspective, and certainly our property remedies might, one of the reasons that we funnel these issues through property is that property kind of looks that way. But we also know that people don't squat for all the same reasons, and different reasons for squatting present different threats and different challenges vis-a-vis the state. And arguably, what I would, I would argue that when you look at political squatting versus housing housing precarity, for squatting as a response to housing precarity, you see those two different threats, but from different ends of the spectrum. And so it would be reasonable for the state to respond differently. Political squatting is much more of a direct challenge to the state of revealing or expressing some concern about the state's legitimacy, whereas housing precarity is really a reflection of the on-the-ground realities where the state has failed to effectively provide housing. And I think it gets complicated because those two things often get merged. And I think we've seen that in Spain, particularly in the last 20 years, where the political squatting has really taken up housing as a primary animus for why for its responsive actions. And so sometimes that gets a little hard to unpack, but at the same time, I think the instinct of the question is exactly right, that we shouldn't necessarily treat things similarly just because they're engaged in the same action. That's somewhat what we are trying to do, is unpack the challenge, the messy space, as Lorna calls it, the messy space that exists, and not be distracted by putting frames around problems.
Okay, thank you. I have another question, in this case for Drs. Matusik and Dinisi. The question says, both in Italy and in Poland, there's a compensation for landlords in case the tenant has to be evicted, but there's no alternative housing in Poland, or the procedure lasts too much, such as in Italy. Is this very costly to the state? How much does this cost? Dr. Matusik, you have the microphone. Yeah.
Yes, sorry. Okay. So yes, in fact, we have in our Tenancy Protection Act the mechanism to pay damages for the owner because of the non-fulfillment of the obligation to give a social housing for evicted person, and it's a big problem for the Poland. The debtor of this obligation is the municipality. So it's not a debt obligation of the state treasury, but for the self-government. This is the basic unit, municipality. The amount of this, the level of this damages is connected with the rental market. So the level of the damages is of the level of the rent, which could be on the market level. Yes. So it's the third part of this damages, the rental market. But the provisions about these damages is so general that owner could also demand from the municipality lucrum cessans. So the benefits which was lost because of the occupation of the flat, and this is a problem for the courts, because owner could say, for example, that he wants to open a market in the premises, or he has a candidate for the tenancy. For example, he wants to open a business there, and the lost benefits are the large amount of money. Probably the provisions in Polish Tenancy Act are too wide about these damages. And of course, many municipalities goes for the settlements agreement with the owners, and this is the best way to pay the damages, to make a settlement with the municipality. I hope it's enough for this topic.
May I want to integrate with the Italian part. In case of delay in enforcing an eviction procedure, as I said, there is this new decree law, and about how how much is the amount of the compensation for owner, the law specify first that is not a full compensation, but just an indemnity. That in civil law, in Italian civil law system, indemnity refers to equitative criteria of quantification of the damage. So it's not a full compensation. And these rules also list the criteria for quantifying the damage. And of course, there is the duration of the unlawful occupation, the possible fault and liability of the owner in determining this situation and in activating for the enforcement of the procedure. And also the third one is the condition of the building. If it's in good condition, this influence the quantification of the damage. But in any case, it's lower than a full compensation. I hope to have answered to the question.
Thanks to both. Quite interesting, the regulation in your countries in this sense. We have another question for Marc. The question says, what do you think about recent policies in Catalonia allowing squatters stay at squatted property for 6 months if there's no alternative of social housing available, regardless whether there's coronavirus or not?
So I just want to ask a clarification. Was that a new rule implemented during COVID?
No, it's regardless of the COVID situation, according to the question.
Okay, so I think one of the things that if we're approaching the problem as a housing problem, and my sense in Catalonia is that squatting has largely, while it has a political nature, maybe the most pressing aspect of it is a housing problem because of the reduction of affordable housing available for individuals. And so if you're framing the problem from that perspective, then I think that makes sense, because in a lot of ways what you're doing is you are giving individuals the opportunity to maintain some housing stability while attempting to find legally appropriate spaces to live. It seems to me to be a mediation where you're giving the owner the opportunity to reclaim his property in a decent period of time, or a reasonable period of time, 6 months, and then you're giving him, but you're also giving the squatter time to find legally negotiable space. So if the problem is framed from a policy perspective as just a housing problem, then I think that it makes some sense. I can see how the state gets there. Yeah. Okay,
thanks. And finally, Dr. Kenna, well, first he makes one suggestion and at the end a question. He says, different countries have different constitutional provisions on the social function of property, justifying by various levels of interference in property rights. This may occur for various social purposes, such as roads, planning, housing, infrastructure, etc. And he suggests it is possible to draw up a scale model comparing countries and regimes, or are we starting from the wrong place? And he adds another question. He says, usually the planning system is based on the principle that the state has the right and the need to alter the bundle of legal rights that relate to property with minimal compensation. Should the same apply to housing policies? As they are general questions, I think that any of the three speakers can address them.
I'll try just to say something about social function, because first of all, there are two really interesting suggestions, and I would like to say thanks to Professor Kenna. But about social function, in Italy we experimented a big contrast between constitutional courts and the European Convention of Human Rights, according to the level of protection to be guaranteed on to property rights in general, because of a different perception of social function by the European Convention and our system. So probably if we look at other all countries of the Council of Europe, probably we can perceive that there is different notion of social function, and this may complicate the investigation you suggest. I don't know if what you think about that, but my perception in looking at the Strasbourg case law is that there is not an European consensus on property ownership and property right as a social function. I hope to be added something useful.
I think that's exactly right. I'll agree with Professor Dinisi, and I'll say, you know, one of the things that we do early on in the book is we talk about the place of property in constitution making, for how property has shaped the way, or how property norms have shaped the way different states have perceived their constitutional projects. And we use the term nomos to talk about this, that there is a that there are stories and narratives and norms that we all articulate around property. And you know, in the U.S., you know, the property norm is one that's mixed between entrepreneurship and sort of self-sufficiency, self-resilience. You know, kind of moving west into California. It becomes this kind of primary way that we think about our property norms, and as it was shaped within our constitutional frameworks over time. And the same thing in Spain, and relating to how ownership and home ownership have shaped the way people think about the obligations of what these human rights or these social obligations of property mean in these contexts. And so I think, on the one hand, I think maybe the question isn't, and to just push back a little bit on your question, Pojdrik, is to say maybe the question isn't, is it possible to draw a scale model where we're looking at that particular, at how each of these things are equal, but that we can draw scale models that account for how they're different. And so we can draw scale models that take into account the narrative differences and the normative differences that different societies deploy in relationship to their property norms and their constitutional norms, as they shape expectations around housing and as they shape expectations around what it means to have a human right norm. Does that make sense?
Yes, fine. I don't know if Dr. Matusik wants to add something.
Maybe at first I want to say that we have to ask a question: what is the ownership in legal system? From Leon Digui or the Pope Leon XIII, yes, the ownership was called as a social function. But in Poland, in Eastern Bloc, the former owners, have been so affected by the taking, affected by the nationalization. So talking about property as a social function is mentally difficult to pass, I could say. And another problem is the definition of the functions, of the social functions. So what is the social function of the state and function of the state, and how deep this function should interfere with the ownership? For example, in Poland we have a big problem with media delivery networks which are located on the private lands, private immovables. Because state enterprises at 20th century built the networks, electricity, pipes with water and etc. Without legal titles to the land. And everyone knows today that if want to have electricity in house, it is necessary to put the networks on the lands. But the particular owner of the land wants large amounts of money, of damages, or of course to put the infrastructure from the outside from the land, because it is his ownership. So the balance between the interests is the hardest thing to do in contemporary systems. For example, in Poland. So I don't know exactly where starts or where the ends the ownership and start the right of the state to take an ownership, to interfere, to limit the scope of the ownership. It's a hard problem to solve, I think, a philosophical problem, and the way of thinking about the state and its function. So in Poland, we could say that talking about social function, as I said, very hard to pass because of the history.
Perfect. I think we covered all the questions. You can also read some comments. Here, for example, Professor Alterman suggested that there's a weak linkage in the wording of constitutional property rights. You can read these comments after. And to conclude this seminar, I would like to give the floor to Professor Dr. Nassarre, Director of the UNESCO Housing Chair.
So good evening to everybody. Good morning to Marc, I think, and to our listeners from overseas. Thank you very much for this exciting webinar. Thank you very much also to our speakers for accepting our invitation to it. It has been a real pleasure to know more about nationalization and this process during decades in Central and Eastern European countries. That's why we have put the title from expropriation to expropriators, now listening about squatters and people seeking for a home somehow when there are no resources there are public resources available to them. So anyway, thank you very much for all the questions as well, for the discussion and for your time, and looking forward to meet you again somewhere else. Take care, stay healthy, and see you again soon. Bye-bye.
Thank you very much.
Bye.
Thank you.
Bye. Thank you
so much.